The Supreme Court just issued its final decision in Case v. Montana, a Fourth Amendment case involving a warrantless entry into a gun owner's home. We covered the details of the case in an earlier video. But now the Supreme Court's decision has left gun owners with little legal protection if cops decide to become a community caretaker. Today on Law and Ammo, I'm going to discuss SCOTUS's latest verdict and what it means for the future of the Fourth Amendment and gun rights in the United States. The Supreme Court just ruled against gun owners and their Fourth Amendment rights, dramatically expanding the power of law enforcement to break into your home. Thanks to the recent decision in Case v. Montana, the Supreme Court has blessed warrantless home intrusions for what it calls community caretaking purposes. In fact, because they are acting under the auspices of do-gooders and not for law enforcement purposes, the court held that police do not even need probable cause of any crime to break down your front door with a battering ram. And so today we're going to take a look at what happened, the Supreme Court's decision, and what it means for gun owners. I'm Phil, and you're watching Law and Ammo. While this recent Supreme Court case may have been decided with an outcome in which we disagree, there's another case we cannot afford to lose. That's GOA's one big beautiful lawsuit against the National Firearms Act. While short-barreled firearms, AOWs, and suppressors are now tax-free thanks to President Trump's One Big Beautiful Bill Act, the NFA's registration requirements remain. So please consider becoming a member at gunowners.org or donate to help us dismantle the National Firearms Act. Now back to the video. A few months ago on this channel, we covered Case v. Montana at length. I'll refresh your memory for the case, but for those who want all of the details, I'll link to our previous video in the description. Case v. Montana centers around the warrantless entry of a Montana man's home, a man named William Trevor Case. Montana police were conducting a so-called welfare check on Case. Then after much back and forth, the police decided to enter his home without a warrant before shooting him in the arm and arresting him. So what precipitated this welfare check and the warrantless entry? Case was known to the police and earlier in the evening had called his ex-girlfriend and allegedly threatened self-harm. And apparently, he told his ex-girlfriend that if she called the police to his house, he would harm them. Ignoring his warnings, Case's ex-girlfriend called the police. In response, 4 officers went to Case's home. As it turns out, a few of the responding officers were familiar with Case, having dealt with him in the past. They viewed this as a hollow threat, saying that he had a history of mental health issues and he had previously attempted suicide by cop. After arriving and finding the house locked, the officers stood outside for nearly 40 minutes, shining flashlights into the home and announcing themselves. Officers reported seeing an empty handgun holster and notepad, but no sign of Case himself. Then after all this time had passed, the officers declared that a sudden emergency existed. As their rationalization went, since they saw a pad of paper on the table, they could assume that this meant Case was writing a suicide note. So now convinced by a pad of paper that Case had harmed himself, the police went to their cars, retrieved their ballistic shields, drew their guns, and made entry into the home. That is, they battered down the front door. Their justification was that they were just engaging in community caretaking, because after all, people with your best interest in mind always bring ballistic shields and guns to protect themselves. After conducting a sweep of the home, one officer found Case hiding in a closet. Upon finding Case, an officer noticed a, quote, dark object near Case's waist. Assuming this to be a gun, the officer fired a shot which struck Case in the arm. As fate would have it, that dark spot turned out not to be a gun. But the officers later found a handgun in a laundry basket nearby. Having fully caretaken of the community by shooting the home's unarmed occupant, Case was transported to the local hospital to treat his police-inflicted gunshot wound. By then, objecting to his caretaking, Case sued. And his case made it all the way to the Supreme Court, presenting the court with this question: whether law enforcement may enter a home without a search warrant based on less than probable cause that an emergency is occurring, or whether the emergency aid exception requires probable cause. Translation to all of this: Can the police break down your door without a warrant or any probable cause at all based on the thinnest justification that something inside might be wrong? Believing that the Fourth Amendment prohibits this sort of outrageous activity, we at Gun Owners of America filed an amicus brief in support of Case. And even though this case involved a tense situation and threats of harm, we can see how an adverse ruling could undermine the Fourth Amendment's protections for all of us. And so we argued to the court that the Fourth Amendment's original basis in property rights should control this case. Police trespassed on Case's private property, and so they should have obtained a warrant, plain and simple. Unfortunately, the courts below had not focused on property rights, but instead on whether the police were reasonable. And that standard of reasonableness is based on a federal judge's idea of what is and is not reasonable. As GOA explained it, if reasonableness is the standard by which the Fourth Amendment is to be interpreted, then the Fourth Amendment ceases to have any objective meaning. And to be clear, experience has shown us time and again that judges are often some of the most unreasonable people in the country. Not to mention, what good is the Fourth Amendment protection against unreasonable searches and seizure if the government can assert some vague community caretaking role and burst into your home with guns drawn for your own good? Let's play for you Case's lawyer's opening statement outlining our point perfectly.
Thank you, Mr. Chief Justice, and may it please the court. This court has never allowed state officials to force their way into someone's home without a warrant or probable cause. It should not start now. There is no liberty interest more deeply rooted in the Fourth Amendment than the sanctity of the home. The court has long recognized that physical entry of the home is the chief evil against which the wording of the Fourth Amendment is directed. And the facts here well illustrate what's at stake with such entries. The police entered Trevor Case's home without permission, a warrant, or even probable cause, and they ended up shooting him in his own house.
His argument seems pretty reasonable to me, but apparently the Supreme Court didn't agree. In a remarkable 9-0 unanimous decision, the Supreme Court ruled against Case, holding that, given the circumstances, the police did not need a warrant to enter his home. And so what does all this mean in practice? Well, according to the Supreme Court, police do not need probable cause to break into a gun owner's home without warrants and just shoot them. In a unanimous opinion written by Justice Kagan, she outlined the court's reasoning. In the 2006 case, Brigham City v. Stewart, this court held that the police officers may enter a home without a warrant if they have a objectively reasonable basis for believing that someone inside needs emergency assistance. The question presented is whether that standard means that officers must have probable cause for the intrusion as they typically would when investigating a crime. We hold it does not. To make matters worse, Justice Sotomayor chimed in with her own concurring opinion, and her position is truly bonkers. The risk of escalation by warrantless police entry is also heightened by the prevalence of firearms in nearly half of America's households. Thus, she claimed, police may employ more forceful tactics when they know a firearm is in the house. Hold on a second. Is Justice Sotomayor insinuating that police have more legal leeway to use force if someone is merely known to possess firearms? A warrantless entry into somebody's home and shooting them is already tyrannical, but justifying that use of force just because the victim happened to be a gun owner? That is unacceptable. Given the fact that gun owners are statistically more law-abiding than the average citizen, makes this statement by Sotomayor even more confusing. Treating gun owners as presumptively violent criminals is dangerous, to say the least. If the Supreme Court sees this warrantless invasion and shooting as community caretaking, I think I can speak for most gun owners when I say, please stop caring for me. With its case decision, the Supreme Court has created a lot of problems for itself and the country. Armed with increasingly broad exceptions to the Fourth Amendment's warrant requirement, law enforcement mission creep always results in the exception swallowing the rule. Meaning, if all the police must do is articulate some non-credible suspicion that someone inside may need help, they increasingly will rely on such claims to avoid obtaining a warrant before breaking down front doors. Oh, this flashbang? Well, that's for your own good, comrade, to keep you safe or something. Worse still, governments given the power to violate constitutional rights at will rarely give that power up voluntarily. The excerpt from Justice Sotomayor's separate concurrence, while not the holding of the entire court, reveals a lot about how some justices view gun owners, and how far some of them are willing to go in hollowing out the Fourth and Second Amendments. Giving the police more power to violate the Fourth Amendment is not what the founders intended, and we'll do everything in our power to help correct this decision in a future case. I'm Phil with Law and Ammo. Thanks for watching.